Good afternoon. A woman convicted of DWI is taking her case all the way to the state Supreme Court, saying she was charged too harshly. The decision could set a precedent. News 13's Jackie Kent has more.
Kim, if she wins, law enforcement could lose a powerful and convenient tool they use to charge drunk and drugged drivers.
A woman's aggravated DWI case from 2011 is heading to the Supreme Court of New Mexico. Larissa Vargas blew a .04, then refused a Bernalillo County deputy's request to draw her blood to see if she was high. That refusal alone boosted her DWI charge to aggravated DWI. She was convicted. The State Court of Appeals lowered the conviction to a simple DWI, saying there was no proof it was aggravated.
This is the first time that the New Mexico Supreme Court has had to deal with the ramifications of the United States Supreme Court decision in Birchfield versus North Dakota.
That 2016 North Dakota case states an officer can't make a driver take an invasive blood test without a warrant in misdemeanor cases.
The state can't threaten you in order to make you give your permission. I think that is a very important principle to uphold.
Prosecutors are asking the state Supreme Court to affirm Vargas's aggravated DWI conviction, arguing the federal ruling should not apply to cases before 2016. New Mexico's Implied Consent Act gives officers the ability to charge drivers who refuse to take a breathalyzer or blood test with aggravated DWI. Leverage officers use to persuade people to take the test, which frequently happens.
Do you think it's too invasive or even unconstitutional?
100%.
Local defense attorney Osama Rashid says this case could change the precedent for how officers charge people.
It's about whether you can then increase the penalty for somebody refusing an unconstitutional search.
No word on when the state Supreme Court could rule on this case. Kim, back to you.
Okay, thanks, Jackie. Now, Vargas was initially convicted of aggravated DWI because she failed the field sobriety test and showed signs of impairment along with that refusal to take the blood test. Now, the Court of Appeals lowered her conviction to a simple DWI because there was no proof it was aggravated without that blood. Now, that blood test, they said again, would have been unconstitutional without a warrant.